Welcome, everyone. My name is Eduardo, and on behalf of the NUS Center for International Law, I'd like to thank you for joining us today in this webinar, which, as you know, is titled The ITLOS Advisory Opinion on Climate Change. What does it all mean? And to help us make sense of this advisory opinion, CIL has assembled a team of 4 leaders from different backgrounds. First, we have our very own Dr. Niloufar Oral, who is the director of the NUS Center for International Law and a member of the International Law Commission. We also have Dr. Lan Anh Nguyen, who is the associate professor at the Diplomatic Academy of Vietnam and director general of the Academy's East Asian Institute. We have Ms. Amanda Chong, who works at the Attorney General's Chambers of Singapore in the International Affairs Division, having been directly involved with the advisory proceedings before ITLOS. And we have, last but not least, Ms. Sophie Marjanac, who works for Client Earth, a very active NGO in respect of climate change, also regarding the advisory proceedings. And to help us moderate these webinar, we have Danielle Yao, who is the lead of CIL's program on climate change law and policy. Daniel?
Thank you very much, Eduardo, and good day to everybody online, and a warm welcome as well to our very distinguished panelists. Particularly privileged today to have such an eminent panel to share your insights, and also I should mention particularly privileged by a presence of Dr. Nguyen, who has just recently been nominated by Vietnam as the first ever Vietnamese candidate as a judge to the ITLOS. So what is our session about today? In a first for the International Court or Tribunal, the International Tribunal for the Law of the Sea issued a unanimous advisory opinion on states' obligation to protect and preserve the world's oceans from climate change impacts within the framework of ITLOS. ITLOS found that greenhouse gas emissions absorbed by the oceans constitute marine pollution, and that states are consequently required to take all necessary measures in line with best available science to reduce greenhouse gas emissions to the fullest possible extent, in line with UNCLOS and other relevant international legal obligations. But what are the implications of the advisory opinion for policy decision makers? What is the normative impact of the advisory opinion as a matter of the development of international law? What is the potential application of the advisory opinion to future climate-related litigation and discourse? This is what we will turn to today. For the first segment, I will invite each panelist to speak for about 8 minutes, followed by about 35 minutes of moderated Q&A, and I will invite audience to use the Q&A functions to submit your questions. Let me first turn to Dr. Niloufar, if I may. Dr. Niloufar is also a member of the course's legal team that had requested for this advisory opinion. So can I invite you to provide us with an overview and reflections on the notable elements of the advisory opinion, the notable substantive elements of the advisory opinion, and to what extent has the advisory opinion advanced course's objectives in making the request, and how will they in particular impact on government's policy and actions to address climate change? Over to you, Niloufar.
Yeah, thank you so much, Danielle. And it's really a great pleasure and honor to be on this panel with such very eminent panelists. I'm really delighted, and I'm also really thrilled to see that we have so many outstanding women on this panel as well. So good. Yeah, so to answer your question, first of all, a little bit about COSIS, and I'll rely on you to give me warnings on the time. I have the great privilege of being a member of the legal expert team of the Commission on Small Island States. And I think it's really important to put this in the context that this started off by an agreement with 2 states from Tuvalu and Antigua Barbuda And now there are 7 member states. But of course, as we know, climate change will impact some of the most vulnerable states, and particularly small island states. So the idea was to establish a commission that could build capacity, knowledge, and work on climate change issues. And one of the first steps taken was to prepare an advisory opinion request. Why is this important? For many reasons. One, it was initiated by small states. I think this is so important to underline, such as the ICJ advisory opinion. And when we think of international law, I want to put it in that context, that international law does give a forum for small states. And look where we are. The signing took place at COP26, as they say, in the margins of COP26 in Glasgow. Actually, it was signed in Edinburgh, I believe. And in a short period of time, that was what, 2 or 3 years ago? I lose track of time. But so one of the first undertakings by COSIS was to put it together a team, a legal team. And very important was this team be diverse, not only in terms of regional diversity, but also age diversity and gender diversity. So we had, those representing youth and then some very experienced. Now, having said that, I think that from the COSIS perspective, the opinion could not have been better. This is an extremely robust opinion. First, as you said, Danielle, was unanimous, and this is important. And while we all know that advisory opinions are not binding per se, they are authoritative. So when you have a unanimous opinion from ITLOS, the Tribunal for the Law of the Sea, stating that, number one, greenhouse gas emissions constitute pollution. This is significant because we had no authoritative statement on whether greenhouse gas constituted pollution. And what does this mean for policymakers and states? Well, at the international level, this will kick in certain conventions and treaties that address pollution, including IMO, which already is working, of course, on greenhouse gas emissions, but domestically as well. So now states domestically and under their domestic laws that cover pollution, and not just marine pollution, because this is one of the key issues. The Law of the Sea Convention covers pollution from all sources. And the advisory opinion made this very clear. We're talking not just about marine pollution, vessel sources of pollution, but pollution from the atmosphere. And that, of course, means greenhouse gas emissions as well, and from all sources. So this is very significant. So it's an authoritative decision. It will obviously trigger the application of other conventions, regional, international, and also domestic law that address pollution from all sources. And having said that, the tribunal also established a very high standard, but I should go back. Another important aspect of this decision is that there was a bit of uncertainty in terms of how the Paris Agreement would play into the obligations under the Law of the Sea Convention. And the Law of the Sea Conventions have some very clear obligations. And the Paris Agreement is important, particularly because now it sets this temperature threshold. And so there are some states who are arguing that the nationally determined contributions under Paris would suffice to meet the obligations under the Law of the Sea Convention. Well, the tribunal made it quite clear that while the Paris Agreement is important, it's the primary agreement, or the UNFCCC as well, for climate change. Basically, Law of the Sea Convention stands on its own feet, and the Paris Agreement, where relevant, will inform the Law of the Sea Convention obligations. And so that, of course, takes into account the temperature target. So the convention, though, then implementing the convention in terms of, for example, under Article 194, where the convention requires that all necessary measures be taken to prevent, reduce, and control marine pollution, the tribunal said the standard of due diligence is stringent. It's a very high standard. And given the high risk of serious and irreversible harm to the marine environment. But here, of course, we also have the question that comes up, and maybe others will speak about that, but I won't address the question of how CBDR or the differentiated responsibilities would apply. Another important element that will impact domestic policymakers and laws is that it's clear that from this decision, state parties now will have to can take into account the impacts of land-based activities that can impact the ocean, the marine environment, when they conduct environmental impact assessments. And this is, I think, one of the major issues, of course, how this will be done. But in my opinion, this was one of the problems we had, always linking the land activities to the ocean. And this opinion is important for that reason. I would just also, the tribunal address ocean acidification. And this is, again, these are firsts. We've never had a authoritative, this high-level decision concerning the impact of climate change on the ocean and the marine environment. And ocean acidification is, of course, one of the very important impacts. And also the tribunal made for the first time adaptation part of the obligation to protect and preserve the marine environment. So I know my other panelists will also add, I don't want to take up all the time on this, but this is really a very impactful, important decision, and states have to take it into account because, last but not least, we hear about climate litigation at domestic level. This also opens the door to climate litigation for states who are not implementing the requirements under the Law of the Sea Convention, cases that can be brought at the national level, particularly for state parties to Law of the Sea Convention, but we can also argue about how much of this is also customary international law. So I will stop there. I wasn't given a warning, but I hope I didn't go over time.
Perfect. Thank you. Perfect. Perfectly on time. And thank you for sharing with us all the key firsts of these decisions and the potential implications. And I think other speakers will also elaborate further on the EIA points and the CBDR points. So that sets a great context for our further discussion. And now I'll turn to you, Lanan, if I may. Would you share with us your general observations about the significance of the AO? And in particular, what is the import of the findings that the obligations under Article 1941 does not refer to the principle of CBDR and respective capabilities as such? It does contain some elements common to this principle. However, the ITLOS did not appear to make any reference to the notion of historical contribution to the environment at stake. And I was wondering how significant is this omission and what lessons can we draw from the AO on questions of treaty interpretation, building off the earlier points from Niloufar. Over to you. Thank you.
Thank you, Daniel. First of all, I'd like to follow up with the previous comment on the significance of the advisory opinions. I believe that the significance of the advisory opinion lied in its ability to clarify and reinforce the specific obligation of state under UNCLOS to address climate change. By integrating scientific evidence from the IPCC, for example, and numerous international submissions, the tribunal has established a robust framework for interpreting environmental obligations. The authoritative guidance will be instrumental in shaping national policy and international agreement, ensuring that states take concrete actions to mitigate the impacts of anthropogenic gas house emissions on the marine environment. And the advisory opinion also signal a clear commitment and strong message to government and industries to protecting the marine environment from the damaging effect of the climate change. And I'd like to continue by comments on some of the procedural aspects of the advisory opinions. I believe that the advisory opinion have very creative in applying the amicus curiae in its proceeding. And I believe that by applying the amicus curiae, it plays a vital role in enriching the deliberative process. By allowing third party to submit their expert opinion and insights, and in this case, I think the number of states have submitted their written submission has been remarkable high. There were 43 state countries participate, 8 international organizations, 9 non-governmental organizations, and 1 UN special rapporteur. And by allowing amicus curiae in a wide range of array of participants, the tribunal demonstrates a commitment to a transparent and participatory process. The inclusive procedure not only added legitimacy to the advisory opinion, but also ensured that the interpretation of UNCLOS obligations were grounded and in a diverse range of perspective and expert insights. And you mentioned before, Daniel, that treaty interpretation also play a very important part in the advisory opinion because the core legal questions raised by the Commission were to interpret the specific legal obligation under Part 12 of UNCLOS. So in addition to address the legal questions, the ITLOS, in addition to apply the traditional method of treaty interpretation provided for under the Vienna Convention on the Law of Treaty, has also taken an approach of interpretative in advisory opinions. And that approach showcases a dedication to systemic integration of international law. By harmonizing UNCLOS obligation with broader environmental principle and scientific evidence, ITLOS ensure a coherent and dynamic application of legal norms. This method not only reinforces the relevance of international treaties in addressing contemporary challenges, but also underscores the adaptability of international law to evolving global issues like climate change. And moving beyond the interpretation of UNCLOS itself, I have to draw the attention to the application of the rules of reference in the advisory opinions. The application of the rules of reference in the advisory opinion underscore the importance of the constitutional and framework nature of UNCLOS. By referencing other agreements such as the UN FCCC, the Kyoto Protocol, the Paris Agreement, like Professor just mentioned before, Annex number 6 of the Montreal Protocols, Annex number 6 of the MARPOL, Annex 16 of the Chicago Convention, the Montreal Protocol, including the Kigali Agreement and other IMO conventions. The tribunal ensures that the UNCLOS obligations are interpreted in a manner that consistent with a broader international environmental rules and standards. The approach not only enhances the coherence within the international legal framework, but also strengthen the capacity of state in addressing the multifaceted environmental challenges comprehensively. And moving to your question related to the principle of CBDR, I believe that in interpreting the concrete obligation provided for under paragraph 1 of Article 194, when we read Article 194, there's a hint for such principle in the wording that at their disposal in accordance with their capacity. However, if we just read that wording, it seems like a little bit vague. And therefore, in its advisory opinion, the tribunal reaffirmed the principle of common but differentiate responsibility in its advisory opinion. And by reaffirming that principle, the tribunal reinforced the notion that while all states have a shared obligation to protect the marine environment, their specific responsibility may vary based on their individual capacity and circumstances. This principle acknowledges the varied economic, social, and technological capacity of different states, ensuring that developing countries are not disproportionately burdened. And by integrating the principle of CBDR into the interpretation of UNCLOS, the tribunal promote a kind of equitable and realistic expectation for state party, fostering a more inclusive and effective approach to addressing marine pollution and other environmental challenges. One may argue that, on the one hand, the tribunal emphasized on the application of the principle of CBDR, but the tribunal may fail to link that principle with the specific obligation to provide technical assistance and to treat the developing country in differential treatment. However, I think in the advisory opinion, they already touch upon those specific obligations. They just fail to connect them together. And I think it's have room for developing country to make use of the advisory opinion later on. So I may stop here and looking forward for the Q&A section later on. Thank you.
So thank you very much for that intervention. Very important remarks on the importance and drawing attention to those procedural aspects of the decision and how the legitimacy was enhanced through a very widespread, diverse, participative process, and certainly a lot of interventions in this regard. The comments on systemic integration is very important, and I'd like to turn to that also during the Q&A later to explore that a little bit later. And also thank you for the comments on CBDR. And hopefully later we will have time to also turn to the other panelists to see if they have any thoughts on the CBDR and whether there was any significance in the omission of the reference to historical contribution, given the emphasis on relative sort of capabilities in this regard. With that, Amanda, can I turn to you on your thoughts on the advisory opinion and particularly on the implications of the ITLOS findings on the relationship between UNCLOS and UNFCCC, which Lanan had already referenced, but could you go further into it? Because ITLOS took the view that the UNFCCC regime is not lex specialis versus vis-a-vis the UNCLOS, and that as a consequence, the obligation under UNCLOS, following a stringent due diligence standard review, could go beyond the obligations under the UNFCCC. So should this have any impacts on states' domestic climate change policy measures or in the undertakings in the next round of NDCs under the Paris Agreement? Turn over to you, Amanda. Thank you.
Thanks very much, Danielle. Let me begin by quickly contextualizing Singapore's interest and approach in the advisory proceedings. As a low-lying small island state, Singapore is very vulnerable to climate change and rising sea levels, and we're also a strong supporter of the multilateral approach under the UNFCCC and Paris Agreement, which reflects the nature of the climate change problem as global and collective. Unlike other examples of pollution, such as oil spills and discharges of substances, each instance of greenhouse gas emission may not on its own cause any deleterious effects, and the scale of the overall global emissions is the problem. And finally, this is very well known, but Singapore regards fidelity to UNCLOS as important, particularly preserving the balance of rights and interests negotiated by states as part of a package. And this really informs Singapore's decision to focus our oral statement on a close text-based analysis of the relevant UNCLOS provisions in order to suggest a framework of how external legal norms are incorporated under specific UNCLOS provisions. And in our oral statement, we term these entry points. So the ITLOS advisory opinion actually reflects many points generally agreed by states, chief of which was UNCLOS covers climate change. It also included the relevance of due diligence and the duty to cooperate. But I shall focus my comments on how ITLOS, the advisory opinion, brings clarity to one of the key areas of divergence in the advisory proceedings, which was the relationship between UNCLOS and the UNFCCC regime. At the advisory proceedings, states generally agreed that UNCLOS and other treaties related to the protection and preservation of the marine environment should be interpreted and applied in a complementary and mutually reinforcing manner. But there was actually a divergence of opinion as to what complementarity entailed exactly. For example, as Nilofer alluded to, some states argued that UNCLOS obligations in relation to climate change only required states to comply with their existing obligations under the Paris Agreement. But the tribunal made a clear statement that in relation to the obligation under Article 194(1) for states to take all necessary measures to prevent, reduce, and control marine pollution from anthropogenic greenhouse gas emissions, it cannot be satisfied simply by complying with the obligations and commitments under the Paris Agreement. And the tribunal said that UNCLOS and Paris Agreement are separate agreements with separate sets of obligations. Paris is not lex specialis in relation to UNCLOS. Therefore, Paris Agreement does not modify or limit or supersede the obligations under UNCLOS. So the clear implication here is that compliance with the Paris Agreement does not exhaust states' obligations to protect and preserve the marine environment from the adverse impacts of climate change under UNCLOS. However, the tribunal did not identify any specific examples of when it would be insufficient to just comply with the Paris Agreement. I think this could arise if, for example, future scientific evidence necessitates more ambitious actions being taken. However, the tribunal also did not reinterpret the balance of mandatory and non-mandatory obligations under the Paris Agreement. And in fact, the tribunal acknowledged that the Paris Agreement does not require parties to reduce greenhouse gas emissions to any specific level according to a mandatory timeline, and instead leaves each party to determine its own national contributions. So based on the advisory opinion, there are several ways in which states must now go beyond complying with the Paris Agreement in order to fulfill their obligations under UNCLOS. And so this really begins with Article 1941 and their interpretation of it, which requires states to take all measures necessary to prevent, reduce, and control anthropogenic greenhouse gas emissions, while still giving states a margin of discretion in order to objectively determine these necessary measures based on relevant factors such as the risk of harm and urgency involved, the best available science, states' available means and capacities, as well as relevant international rules and standards. So the multifactorial analysis of all measures necessary means that compliance with the Paris Agreement is just part of one factor to be considered. So a few observations here on how states must now go beyond complying with Paris in order to fulfill their UNCLOS obligations. First, the tribunal noted that the relevant international rules and standards are not just confined to the Paris Agreement and the UNFCCC, but are part of a wider ecosystem of instruments related to the environment, including Annex 6 of MARPOL, as well as Annex 16 of the Chicago Convention, amongst other instruments. Second, best available science must also be taken into account alongside relevant international rules and standards. And we would see this means that in determining necessary measures, states must take into account the ample body of scientific evidence on the marine environmental impacts of global temperature increases at 1.5 degrees Celsius compared with other temperature levels. And third, in determining what measures are necessary, states must also apply a precautionary approach, according to which states cannot disregard plausible indications of threats of serious or irreversible damage, even when scientific evidence on the scope and impacts of an activity may be insufficient. And finally, the tribunal was also clear that in order to fulfill the duty to cooperate under UNCLOS, it is not enough for a state to simply become a party to UNFCCC or the Paris Agreement. Instead, Article 197 of UNCLOS requires states to participate meaningfully in the formulation and elaboration of rules, standards, and recommended practices and procedures based on scientific knowledge for the protection and preservation of the marine environment. And this was recognized to be an obligation of conduct. And the results achieved by states through cooperation may actually be relevant in assessing states' compliance with the duty to cooperate. So I will conclude by highlighting another significant aspect of the advisory opinion in terms of how it creates a mutually reinforcing relationship between UNCLOS and the UNFCCC regime. And this actually concerns the tribunal's reading of Articles 213 and 222, which are the enforcement provisions that correspond to land-based and atmospheric pollution, respectively. So these Articles 213 and 222 require states to adopt laws and regulations and take other measures necessary to implement applicable international rules and standards. And the tribunal held that applicable international rules and standards refers to legally binding rules and standards, which may be binding either as treaty or as customary international law. And this was actually also the interpretation that Singapore had adopted in our oral statement. So the implication is that in the context of climate change, states must take measures necessary to implement binding obligations in climate change treaties and other relevant instruments. So in Singapore's view, this would include the legally binding obligation on parties to the Paris Agreement under Article 4 to prepare, communicate, and maintain successive nationally determined contributions, or NDCs. And in addition, we take the view that based on Article 3 of the Paris Agreement, parties are bound to fulfill their legally binding obligations in the Paris Agreement with the view to achieving the purposes as set out in Article 2 of the Paris Agreement. So we see Article 213 and 222 of UNCLOS as imposing an obligation for states to take necessary measures to implement, inter alia, Article 4 of the Paris Agreement to prepare, communicate, and maintain successive NDCs with a view to achieving the purposes of the Paris Agreement in Article 2 that includes the temperature goal. And as the tribunal has stated, a failure to implement the binding legal obligations under the Paris Agreement would amount to a breach of Articles 213 and 222. And this would also entail possible recourse under UNCLOS compulsory dispute settlement regime. So I'll stop there for now, and thank you very much.
Thank you, Amanda. There's so much rich, information in your interventions for us to chew over, ranging from Singapore's perspective to the way the tribunal had dealt with the relationship between UNCLOS and Paris Agreement. And I found it quite particularly interesting, your comments, final concluding comments on what it means in terms of meeting the Paris Agreement vis-a-vis obligations under UNCLOS, failure to meet it. But then again, it's quite nuanced, isn't it? Right? It really depends on what is binding under Paris Agreement in the first place. But what is clear is simply meeting Paris Agreement is in itself does not seem to be sufficient based on the outcome in everyone's advisory opinion. So thanks very much for all three previous panelists for the very rich contribution. I'd like to take a little different tack now, and I'll turn to Sophie, if I may. Slightly different tack in this case, looking at the significance of the advisory opinion for future public interest litigation, corporate climate litigation, and also internally on corporate business strategies and governance. What are your thoughts on that? Over to you, Sophie.
Good afternoon, everyone. It's an absolute pleasure to be here, and I'd like to thank the university for inviting me to the webinar this afternoon. I'm an Australian qualified environmental lawyer, and I'm with Client Earth. So Client Earth is an international legal environmental organization, and we take strategic litigation, and we also undertake policy and legal advocacy to encourage both governments and private corporations to protect the environment, to reduce their impact on climate change, and to operate within planetary boundaries. So I have considered my remarks today in light of the findings of the tribunal, but also focusing on what they actually mean for national law and how they might be used in a range of national circumstances, including litigation, as well as the operations of those businesses who are producing the land-based sources of greenhouse gas emissions that were the focus of the tribunal's opinion. So fundamentally, of course, as a matter of law, advisory opinions by the International Tribunal for the Law of the Sea are not technically legally binding. However, they are authoritative statements of the law in question, and therefore they contribute to the development and concretization of international law and shape the international legal order. It's therefore clear that the advisory opinion, will be used and relied upon by lawyers around the world in many different contexts. And particularly this may occur in public interest litigation, like that undertaken by Client Earth and other organizations in our ecosystem. And in first considering how the advisory opinion will affect domestic law, one tends to begin by looking at the way that the national legal system applies and interprets international law, and whether it's what one calls a monist system or a dualist system. Now, the Netherlands, for example, is a very strong monist system. And if we consider the agenda decision of 2015, in which the Agenda Foundation was successful in finding, in its case, claiming that the Dutch state needed to do more in respect of greenhouse gas emissions to protect its citizens, the court found in that case that a state can be supposed to want to meet its international law obligations. And the way that the Dutch court interpreted international law was quite important in grounding that decision. In other states, international treaties and other international law obligations need to be incorporated more legislatively or ratified into domestic law for the courts to take them into account. For example, in the UK, a recent case in the UK involving a fossil fuel project in Mozambique, the UK Supreme Court found that because the Paris Agreement was not directly incorporated into UK law, it was not part of the fundamental considerations that the court needed to take into account. So the difference between monist and dualist systems may impact how the advisory opinion is used in the domestic context. But of course, this is not the whole answer. And the monist-dualist dichotomy is rather more a spectrum than a firm set of criteria. And there are ways in which the advisory opinion may permeate into domestic law despite not being directly ratified. And one can consider and think of many cases in which that may occur. Particularly, there is a trend around the world for what are called framework climate cases against governments. And this is where individual citizens take their national government to court, arguing perhaps under human rights law or under other constitutional law principles that the state is not doing enough to protect the citizens from climate change. And we've had the Agenda case I've just mentioned and many other examples around the world of cases such as that. And one recently in Belgium, in Europe, and there have also been cases in Asia, including in South Korea. And the advisory opinion may impact the decisions made by national courts in those cases, as the courts are called upon by those claimants to apply and interpret the state's international law principles, perhaps under the Paris Agreement, perhaps under international human rights law, and now under the law of the sea. So it will be incredibly interesting to see how litigants take up the principles espoused by the ITLOS. Another clear way in which, and probably I'd say the most important way in which the advisory opinion will affect private interests and the practical development of fossil fuel infrastructure and resources around the world and that means those land-based sources of greenhouse gas emissions are the comments that the tribunal made on environmental impact assessment. Now, this is sort of near the end of the opinion, but I think this is probably one of the most important practical aspects of the opinion, because the tribunal has really reinforced the primacy and importance of environmental impact assessment and the procedural elements of environmental impact assessment in respect of assessing the impact of greenhouse gases. And they made some incredibly important comments, both about the cumulative nature of the climate change problem and the need for greenhouse gases to be assessed on a cumulative basis, and also in respect of taking into account scientific best practice scientific knowledge and the best available science in the analysis of environmental impact assessment. And there are two key controversies in environmental impact assessment, one on the cumulative issue and the second on the downstream impact of fossil fuel projects. That is, the emissions that occur once the coal, oil, and gas are burned in the downstream part of the value chain. And those are referred to as Scope 3 emissions. Under the Greenhouse Gas Protocol, emissions are classified into Scopes 1, 2, and 3. And the issue of the inclusion of Scope 3 emissions in environmental impact assessment has been a fundamentally controversial issue in many jurisdictions for many years. And there's in some jurisdictions a lot of jurisprudence around that. The tribunal offers, I believe, a clear indication and signal to states that downstream greenhouse gas emissions for fossil fuel projects must be taken into account in the environmental impact assessment process for those projects. And this would be an interpretation that would comply with the stringent due diligence test that the tribunal has set up for states when they consider how to deal with and how to implement legal regimes to control the impacts on the marine environment from land-based sources. And also the cumulative...
Thanks very much, Raji. Thanks very much, Sophie. I think that's a very important point that you mentioned about EIA. And I sort of interrupt you. I just wanted to be able to come in and then go straight into the Q&A, referencing your comments about EIA, which I think are very, very important. And I'd like to come back to you again during the Q&A for your other observations on that. So if I may just take off from your last point about EIA, and I think other panelists may have a view on this as well. And I wanted to just throw it out. And if I may just turn to you first, Amanda, because one of the questions that I had was really coming on this point, that the UNFCCC, the Paris Agreement, significant role in domestic and regional climate litigation. Sophie has mentioned much of that as well. In light of the AO, can UNCLOS be expected to play a similar role, notwithstanding the limitation to marine pollution issues? Do you have a view on that? And particularly in relationship to the question of EIA, which Sophie had just mentioned.
Thanks very much, Danielle. I think since Sophie has given such a rich account of how the AO could potentially be used in the climate litigation, I will focus my answer on the possible ambiguities or unresolved issues in the AO, which may affect the way that it can be applied. And let me just caveat that these are my personal views. Sophie did mention about the authoritativeness of the AO. I would also add that it is authoritative also to the extent that a large part of the AO were points already agreed by states participating in the proceedings, and that we consider that the tribunal's analysis was predicated on a faithful interpretation of the relevant UNCLOS provisions. But at the same time, I think a clear gap here is that the tribunal did not address the legal consequences arising from the breach of UNCLOS obligations, as this went beyond the scope of the questions submitted by the COSIS request. but they did refer to it to the extent necessary to clarify the scope and nature of the primary obligations. And I think that, like, for example, they stated that in relation to Article 1941, if a state fails to comply with it, international responsibility would be engaged. And I think this is just a logical consequence of a breach of any UNCLOS provision. As to the extent of how it can be applied and the ambiguities or unresolved issues, I would say that first, while the tribunal did indeed say that states must exercise a stringent standard of due diligence in relation to anthropogenic greenhouse gas emissions, given the potential of severe harm to the marine environment, it did not go on to elaborate on what a stringent standard entails. I think it's quite clear what a stringent standard is, what stringent does not mean, which is to say that Article 194 is an obligation of conduct and not result. The tribunal did say stringent does not mean the prevention of all anthropogenic greenhouse gas emissions from all sources at all times. They recognize that this was in practice not possible. Stringent also does not entail the immediate cessation of marine pollution from greenhouse gas emissions, but there was limited guidance for how to actually apply the stringent standard, so it'll be interesting to see how it is applied in practice. I think another possible ambiguity is the exercise of actually balancing the multiple factors that come into play in the analysis of whether a state has taken all measures necessary under Article 1941, because there is a margin of state discretion, but yet the necessary measures should be determined objectively. So it's unclear how courts or tribunals might weigh these relevant factors, especially as there's no one determinative factor. ITLOS specifically noted that the best available science is just one relevant factor and not the only relevant factor. And it's also unclear the extent to which courts and tribunals would review climate-related decisions and policies made by UNCLOS states parties when they can actually be justified in line with the relevant factors. And finally, I think there is also the issue of causation in relation to the breaches of Article 1942, which is the obligation to ensure that anthropogenic greenhouse gas emissions do not cause transboundary deal with including matters of causation. And I'm sure we're going to get there at some point, so perhaps I'll just stop here.
Thanks very much, Amanda. A good thanks for a quick rejoinder on this issue of emissions and the EIAs and additional viewpoints. I wanted to give a chance to Sophie to come back just to close up this point, because you presented this perspective from states, the perspective of corporates, and in particular, Sophie, in terms of the European sustainability reporting rules. Could you sort of bookend this aspect of the discussion on how it impacts on corporate, Sophie, taking into account the European reporting sustainability regulations and the directives?
Sure. I mean, so currently in Europe, there has been a series of laws recently passed in the past few years, which significantly increase the scale and content of both sustainability reporting by corporates and also the obligations on corporates to conduct human rights and environmental due diligence. And the reporting framework now encompasses a principle of double materiality. So looking not just at what the impact of environmental harm on a company's financial performance, but actually looking at the impact that the company has on the environment. And that concept of double materiality is carried through into the Corporate Sustainability Due Diligence Directive, which is a new European law that really raises the bar for all large companies operating in the European Union to conduct whole-scale environmental and human rights due diligence on their impacts. And so I think particularly for those, the opinion is clearly very significant for companies operating in the shipping and aviation sectors, because it widens the scope of the application of the UNCLOS and accordingly emissions reduction obligations to those sectors, which had previously been excluded from the UNFCCC. So there's a clear new concern or issue for shipping and aviation. But then also other companies now need to be thinking about the impacts of their operations on the marine environment specifically.
Great. Thanks very much, Sophie, for that. I think it's a important point. We're looking at it from states, but also very much looking at the practical impact on corporates. Let me turn to the questions, because there've been questions sent in advance. There's also questions on the chat now. A lot of it has been incorporated into response already. But let me just turn to this more general question in terms of the contributions. And there's a question in the chat on the contributions of the ITLOS advisory opinion in general, and on climate change advisory opinion in particular, in clarifying and accelerating the implementation of UNCLOS, and how can coastal states like Vietnam and Singapore apply these lessons in the context of the South China Sea? Could I turn this question to Dr. Nilofer Oral and also to Dr. Nguyen as well, on your general comments on these questions, this particular question?
Yeah, thank
Nilofer?
you so.
Yes.
Can you hear me?
Yes.
Yeah, okay, good. Yeah,
Yes.
thank you so much. Yeah, I think that the question comes from our audience, from Mai Hong Nguyen, and it's a good question. And I won't speak specifically to Vietnam, as we have obviously Dr. Nguyen here who can speak on that, and perhaps Amanda on Singapore. But the point I think that is important is that number one, I hope it's come out that it's a very powerful advisory opinion that cannot be ignored. States have to take it into account, particularly state parties. And one thing that's very important to underline, and I believe this was highlighted, maybe it was Amanda who highlighted this, that climate change is a collective issue and it requires collective action. And so we've been talking more about it at the national level, but there's also the regional level. And I think this is, I don't know what ASEAN is doing specifically, but I think that from the regional perspective and the ASEAN countries, this would be something to look into. And they may have, I have to say, I've not looked at that aspect, but I think it's very important. So I would underline that. This is a very important decision, and I really hope that there will be momentum on this, because we are all going to be impacted by climate change. We already are, and particularly this region, Southeast Asia, is very, very vulnerable. So I'll turn it over to our very dear colleague, Dr. Nguyen, who can speak on this as well.
Well, thank you, Nilofer. I cannot agree more. And first of all, I cannot speak for Singapore, but let me make a general observation first. I believe that in the advisory opinion, there are more than several occasions that the tribunal mentioned about the urgency of the matter concerning climate change caused by greenhouse gas emissions. And therefore, one of the reasons for it to oppose the jurisdiction is because it is emergent issue and need to be addressed. Second one, because it confirmed that it is a specific legal obligation under UNCLOS, and there are many countries are member to UNCLOS, so therefore such obligation will be bound by the member country, including Singapore and Vietnam. Third point, in 8 arguments in the advisory opinion, the number of principles have been touched upon, including like precautionary approach, principle of no harm, due diligence with a more stringent standard, like Amanda just said before. So clearly it has been elaborated in more details about the specific obligation. It linked from the all the 5 verbs, including in the legal questions like prevention, reduce, control, protection, preserving, and also it linked to other duties under UNCLOS, for example, duty of corporations. And therefore, countries in the region, including Singapore and Vietnam, on the one hand, can be confident with what they have already committed in reducing the greenhouse gas emission during the COP26, for example. On the other hand, they can make use of all the mechanisms to promote for regional cooperation, like Dr. Nilofer just said. And of course, there is a differentiate responsibility between developed and developing country, as the tribunal already emphasized. I cannot speak for Singapore, but for Vietnam, we still consider Vietnam as developing country. So on the one hand, Vietnam can seek for kind of some exception obligation under the international agreement. But on the other hand, it may looking for the mechanism to receive technical assistance in order to narrow the gaps and to coordinate better with the others in order to cope with the, like Dr. Nulifer said, the common issue from the greenhouse emission problems.
Thank you very much, Nguyen, Dr. Nguyen, for that. I looking in view of the time, I'm just going to throw out a couple of questions, and I would invite the panel to pick one question that they would like to respond to within the time available. And the first one is this: how do you foresee or hope to see, in terms of how this opinion would affect the climate negotiations and the parties' approach in the preparation of the next round of NDCs? So what do you foresee? What do you hope to foresee in more aspirational terms? The second question is this. The ITLOS opinion has been criticized in some quarters for scant attention paid to international human rights law, rightly or wrongly. Some may agree, some may not agree. In your view, how can international human rights law, in particular the right to a clean, healthy, and sustainable environment, how could that have affected the ITLOS interpretation of the obligations, the UNCLOS? How can that assist or be relevant in other ongoing pending advisory opinions relating to the climate and climate human rights before the ICJ, before the Inter-American Court of Human Rights, for instance? What is the implication that you see? So these are two particular questions that I would just kind of throw out there as well. The third question relates to the question of best available science. And that has been referenced very well by the comments of the panelists. But the question here is this: in your view, given the sort of significance and the weighty sort of attention paid to the IPCC reports, for instance, by the tribunal, how would this affect a state party's future interactions with the work of the IPCC? Do we expect that to change the nature of the interaction in terms of the experts on the panel, the appointment of the experts, the way the experts do their work? Do you see that sort of impact? So I'll just leave this three on the table first. And Amanda, please feel free to come in as well, the last question, with a specific reference to applying this lessons to Singapore. Thank you. May I start with, may I invite Sophie? Would you like to start us off on this question, or anybody? Sophie, Amanda?
I can briefly make a comment on the
Yes.
human rights element.
Yes.
And just to note that there were two individual opinions from Maria Teresa Infante Caffi and Stanislaw Paluak, who made a comment on human rights. The tribunal's comment, single sentence on human rights, is at paragraph 66, and it just says that the tribunal notes that climate change represents an existential threat and raises human rights concerns. And two of the judges felt that the majority ought to have gone further there, with Stanislaw Paluak actually referencing a decision of the UN Human Rights Committee in the Billy and Australia case, and also the very recent Klima Signorinen case. And I think it's incredibly interesting that these comments were made. And I think this goes back to the principle of systemic integration, because we can see how the international human rights law regime may have influenced the interpretation of the UNCLOS. Clearly, marine pollution can affect human rights. But I wonder whether the conclusion of the tribunal would have been any different had they taken international human rights law more directly into account. They may not have felt capable of opining on human rights remedies, but the interpretation of the UNCLOS and the UNFCCC and the relationship and the relationship of integration between those two regimes does have implications for the ICJ's upcoming opinion, which will have to directly address the intersection of international human rights law and the UNFCCC. And it will be interesting to see whether they follow this approach of integration put forward by the tribunal. And in terms of what the ITLOS opinion means for international human rights law, I'd say that their approach may directly influence the human rights treaty bodies that interpret the international human rights treaties. They do refer to advisory opinions, and as they continue to develop the human right to a healthy environment, I think that the comments in the advisory opinion and the approach to systemic integration will be very influential.
Thanks very much, Sophie. Amanda, over to you, and I'll give the last word to Dr. Claire.
Yeah, so perhaps I can offer a slightly different perspective to what has been said on the issue of the inclusion of human rights. Singapore's view is that climate change adversely affects the human rights of many, and the failure to take adequate action to deal with climate change can indeed amount to breaches of both UNCLOS obligations as well as international human rights treaty obligations. But we saw this issue in terms of a very disciplined analysis of the specific UNCLOS provisions at hand. And so there are UNCLOS provisions which directly refer to human rights, such as, for example, Article 230 of UNCLOS, which refers to recognized rights of the accused shall be observed when penalties may be imposed on foreign vessels violating laws and regulations under Part 12. So we see in that such example, a breach of human rights, treaty rights equals a breach of that specific UNCLOS provision. But what we saw was that in relation to Article 192 of UNCLOS, there is no legal basis for the wholesale incorporation of external rules of international law, which do not address the protection and preservation of the marine environment, because that is what Article 192 is on. So it does not mean that a state is not liable for breaches of human rights laws obligations if it does not take adequate climate action, but rather it is that it may not amount to a violation of UNCLOS, and the remedy can be found outside of UNCLOS, but within the context of those human rights instruments. The consideration of international law obligations beyond UNCLOS needs to be undertaken in the advisory opinion before the ICJ.
Thanks very much, Amanda, for that different clarity on the distinction in the approach that you have described. Dr. Yuen, close us off with your final words on this question or general observations.
Thank you. First of all, I would like to make a comment on the relationship with human rights breach as well. I do agree with Amanda that from the rules of reference, if you look at UNCLOS, it will be going too far if we think the breach of international environmental law linked to the breach of human rights. But it's the vice versa, it's the other way around. Because if you look at the instrument in human rights, then if there is a rules of reference from the instrument in human rights open for the violation, it may link to the violation in the environmental law. So in that way, I don't think the UNCLOS can cover the breach in human rights with regard to the climate change, but that will not prevent I agree with Sophie that it will not prevent the human rights body will think about the way to link between like environmental violation with the human rights in the future. But definitely not within the framework of ITLOS and UNCLOS. Second, I saw some question in the Q&A box. One of the questions is about the liability. I think it's clear from the advisory opinion that the tribunal will only touch upon the specific obligation. They will not talk about the liabilities this time. So it may open for further development in the future, because as long as it found like the violation, the breach of environmental law, then it will incur liability. And in the future, maybe corporate and other national legislation will develop further in that direction. Also, Yuna raised a question of our thought on the potential effect of the advisory opinion in the context of the work under the UNFCCC. I think Sophia touched a little bit upon it. I think in the future, on the one hand, state may be careful in giving the information for the IFCC when producing their report, because obviously from the advisory opinion, some of the scientific evidence from the report has been using to make the conclusion of the tribunal in advisory opinion. But anyway, I think it's the tendency that more coherent, more consistent of the international legal system has been produced. And if the common interest of the state party is to reduce the greenhouse gas emission, and at the end of the day is to contribute to the protection of the planet, then we are in the same boat, and perhaps country instead of avoiding their obligation may find a way to cooperate and coordinate with each other to handle the challenging issue that facing everyone at the moment.
Thank you very much, Dr. Graham, for rounding us off on an optimistic note. We've covered a huge range of very diverse issues today. We don't have time. We probably need to arrange another session just to go deeper into some of these issues we did not have time to look at today, such as the impact of the ITLOS on discussions in other forums, such as offshore carbon capture storage activities under the London Protocol, given the question of carbon and safe storage of carbon. But very rich discussion today. And I'd like to end us off on that final note that Dr. Nguyen had mentioned, the importance of cooperation in tackling this global issue, the role of states, the role of corporates, the role of civil society, and the impact of this decision, of this momentous advisory opinion, which we are still distilling, on states and states in their conduct, states in activities, states in their domestic laws and policies, and even down to the information given to the experts on the IPCC. So lots of ground to cover. Thank you, everyone, for your time. Again, my warmest thanks and deep thanks to the panelists for your time and the time spent preparing and contributing to these discussions, and also to the audience and participants, of which there are over 300 registered ones today. The outcome, the recording will be made available on CIL's social media website for those to continue to refresh our memory, our collective thoughts on this decision. So thank you and good evening, good day, goodbye to everybody. Till the next time. Thank you, everyone. And thank you again.
Thank you, Daniel, for the excellent moderation.